You come home one day and you find something either stapled on the door, handed to you, or in the mailbox. It's either a summons and complaint or it's a notice of a default judgment against you. But the thing that baffles you more than anything is you've never heard of the company. It may be Asset Acceptance Corporation, it may be Catch LLC, Palisades Collection, Sherman Acquisitions, a host of companies known as debt buyers. What happens is your credit card or your bank charged the debt off, wrote it off on their taxes, and sold your debt for pennies on the dollar. They sold it electronically in mass quantities. This particular debt buyer may have bought hundreds of accounts in additions to yours, and they have no paper to back up the debt. But in the complaint, it states that they have the right to sue you and they bring a lawsuit against you. Now, if you're served with a summons and complaint, you have to put in an answer. What I suggest you do is you go to the county clerk's office, the civil court, or the Supreme Court, and ask them for a form answer that you can fill in and file it to prevent a default judgment being entered against you. Some of those affirmative defenses that you want to have are things like standing, statute of limitations, unconscionability, service might be an issue, payment, identity theft might be an affirmative defense, violation of good faith in dealing, latches. Sometimes the debts are usurious. I've seen situations where the amount of the interest is greater than the debt. I'm sure that somebody listening to this video has had that situation. So you want to put in an answer. But if there's already a default against you, you want to go to court and you want to let the court know that there's a default judgment against you. They'll give you a form to fill out where you state that you weren't served, because usually that's the situation, and also a defense. For example, if it's a debt buyer, you're going to say, I don't know who these people are, I don't owe them any money. So the court will schedule a court date if it's a default judgment. If you just put in an answer, it's possible that nothing will ever happen again. But if you do get notice of a court date, you want to go to court and you want to ask for discovery. You want this particular plaintiff, this party that sued you, to produce the records that show that they own the debt and the records that show that they ever notified you of the debt. That's the first thing you want. And if on the return date they do not produce that stuff, the court will give you another date. Will allow them 30 days, 60 days to produce proof that they own the debt and that notice was given to you. If they don't do it, then you should ask for the case to be dismissed. But if they do produce it, then you should ask that the court put the case on for a firm trial date. My experience has been that most of the time the plaintiff debt buyer is never ready to go to trial, and the court will dismiss it for them not being available to go to trial. I'm George Basias. My phone number is 718-721-4441, and you can also reach me at basiaslaw.com, BASSIAS law.com. Thank you.